Good morning, everyone. Welcome to Assembly Judiciary. Welcome to everyone here in Carson City, as well as those in Las Vegas. I don't see anyone yet. But of course, welcome to those watching online, either through YouTube or our Nellis station. With that, I will ask Committee Secretary to please take the roll.
Assembly members Cole.
Here.
Dahlia.
Here.
Gonzalez.
Here.
Gray.
Here.
Hanson.
Here.
Hardy.
Here.
LaRue Hatch. Marzola.
Present.
Moore.
Here.
Nadeem.
Present.
Ortlicker.
Here.
Roth.
Here.
Urick.
Here.
Chair Miller.
Here. And please mark Assembly Member LaRue Hatch present when she arrives. And with that, just a few housekeeping reminders. Just want to remind everyone to please turn down any of your electronic devices. Also, I will provide the number right now because we will have public comment at the end of today's meeting, as well as anyone wishing to call in to testify. Today's number is 888-475-4499. The meeting ID is 818-2256-5843. Again, anyone wishing to make public comment or testify today, we ask that you keep your comments to 2 minutes. We ask that you keep your comments to 2 minutes each. Also, those presenting on bills, we ask that you keep your presentations to 15 minutes each. We will hear 3 bills today, and we will be taking them in order according to the agenda. The first bill we have is Assembly Bill 193, which revises provisions relating to certain victims of crime. And so I will welcome the bill sponsor up and open up the hearing for Assembly Bill 193. Assembly member, I will give you a moment to get settled. I ask that once you and your co-presenters, before you speak, introduce everyone part of your presentation, introduce yourselves, and a good reminder for all of us, because it's difficult for all of us to remember, is to please state your name before you speak, and of course, the first time you speak, to spell your name so we have it correct for the record. And with that, Assembly member, whenever you are ready, please proceed.
Thank you, Chair. My name is Greg Koenig. It's Koenig, and I represent Assembly District 38. With me today to help me present, I have William Horn, Horne. So thank you for giving us the opportunity to present AB 193. We do have an amendment on the table which will add Assembly Member Cecilia Gonzalez and Assembly Member Melissa Hardy as co-sponsors.
Assembly member, is that a friendly amendment?
Friendly, yes.
Okay.
Yes. So AB 193 creates the same access to a free police report that already exists for sexual assault victims. Allowing survivors access to the record can support their applications for victim of crime reimbursement or for whatever other use a survivor may have. Providing free police reports to this subset of victims is a step to supporting survivors on their long road to recovery. And I will turn the time now over to William Horn to go through this bill, and I promise we will not take 15 minutes.
Good morning, Madam Chair, members of the committee. For the record, my name is William Horn with Western Public Affairs, proudly here to support Assemblyman Koenig in AB 193. First, I'd like to talk to you, because we've had a number of people ask, why do you need this? What's the purpose of this? And so I'm going to run through some of the things that survivors of domestic violence can benefit from. So financial relief for survivors. Many survivors of domestic violence face significant financial challenges and struggle to afford the cost of obtaining police records. By offering these records for free, these reports for free, we can reduce financial barriers and ensure that survivors have access to crucial documentation. So it's important to note that survivors who are fall below the poverty line are 5 times more likely to be a victim of domestic violence. So while the cost of a report may seem small to some to get it, some of that is a significant barrier to do that. Access to critical evidence. Police reports often contain essential details that survivors need for legal matters such as protection orders, custody disputes, or criminal trials. Free access to these reports ensure that survivors have the evidence they need to navigate these important processes. Empowerment and control. Survivors of domestic violence often feel powerless. Providing free access to police reports gives them critical information and allows them to regain some control over their legal and personal decisions. Support for legal advocacy. Survivors seeking legal help can use free police reports to provide important evidence to their attorneys, access community resources, and apply different benefits such as victims of crime reports. And this also helps with case preparation and ensures they have the right support in court. I'll conclude with improved safety planning. Access to police reports helps survivors understand the details of violent incidences, which is crucial for developing effective safety plans. This allows them to make informed decisions about their protection. Now, with Chair's permission, I'll walk through the short bill. In Section 1, it basically provides that law enforcement shall, upon a written request from victims, provide a report within 30 days of such a request. All law enforcement agencies concerning domestic violence, regardless of whether that report has been closed by that law enforcement agency. And with that, Madam Chair, we'd open it up for questions.
Greg Koenig, for the record. Just one point is that, all these rights and this law applies already to the sexual assault victims, and it's not changing a single thing. It's just adding the term domestic violence. So the victims of the domestic violence will receive the same benefits that sexual assault victims will receive. So questions at this point?
Thank you so much for that clarification. I don't see any questions from members yet. Assemblymember Gray.
Thank you. Real quick question, please. So victims of crimes, they, typically need a police report for one reason or another, and I'm just wondering, you may not be able to answer this, Assemblyman Koenig, but why aren't we providing copies to people that need them free of charge if they're a victim regardless? Some people need them for insurance claims. I think it's a great idea, just wondering why.
Greg Koenig, for the record, and no, I can't answer that, but I think that might be a great idea for a bill, a good idea for you next time.
Thank you so much. I don't see any additional member questions. I just have one quick question. In Section 1, it says that this shall be available upon written request. And again, I know the goal is to eliminate or alleviate some of these when we have survivors and victors of domestic violence or sexual assault. That process is already cumbersome. And so I was just wondering, is upon written request, is the onus on that person to go in and submit a written request, or can it be simplified where there's a form or an automatic box where we can check, just trying to alleviate one more step in the process for people?
Thank you, Madam Chair. How I understand it, and I do have my client, Liz Ortenberger from SafeNest here, but SafeNest, the large provider of services for domestic violence, and other organizations that do that, have the ability, and oftentimes do, help survivors with such tasks as, navigating these systems, filling out forms, getting it to the appropriate agencies that need this. So during this time where things, are very traumatic for a survivor and stuff, there are agencies such as SafeNest who help them navigate through that, and that would include helping getting this written request for these records. So they need that.
And I ask that too because I know there's a lot of people, I mean, we know the value of Safe Nest and other agencies in our community, but we also know there are people who aren't going through these agencies, who are just stepping out on their own, maybe, with the assistance of their family or friends, or just maybe all on their own, who wouldn't be aware of this service or option. And so just wondering if, and again, I'm just curious for the sake of people, and I know it's not necessarily maybe part of the bill, but in discussions, if there's a way that we can simplify it and just take one more thing off the plate of someone that already has a litany of things that they need to step through.
We'd absolutely be interested in discussing on how to simplify that process, Madam Chair, and at the risk of invoking another bill that's before this committee on lethality assessments. There is a section in there that calls for a form being filled out, and where it's an onus is upon law enforcement to even let that survivor know that they've reached a high lethality level, and then that's in a form that will be created should that bill pass and stuff. So there's one mechanism there.
Okay, thank you so much. With that, not seeing any additional questions, I will go ahead and open it up for support. I will also re-give the meeting ID number for today because it has changed. So those wishing to call in for testimony, today's meeting ID is, the correct one is 862-3953-0890. And with that, again, just a reminder, please state your name and spell it so it's correct for the record. Asking individuals to limit their testimonies to 2 minutes each. And with that, I will begin with support testimony for AB 193 here in Carson City.
Good morning, Madam Chair, members of the committee. For the record, my name is Serena Evans, SERENA-EVANS, and I'm the Policy Director for the Nevada Coalition to End Domestic and Sexual Violence. We support any measure to reduce barriers and hurdles for victim survivors, and so we're in strong support of this bill. Thank you.
Good morning, Madam Chair, members of the committee. For the record, my name is Leslie Pittman, LESLEYPITTMAN, and I'm here today as a member of the Board of Directors of the Domestic Violence Resource Center, which is located in Northern Nevada. We are the longest-serving domestic violence survivor support group in the state. And I just wanted to be here in support of this measure, but also in addition to the very good reasons that Mr. Horn laid out for why it's important for survivors to have this information, is it's also information that's needed to help them get out of a lease that they may be in with an abuser, and meeting the requirements to take time off of work. So thank you.
Chair, members of the committee, Jonathan Norman, NORMAN, Nevada Coalition of Legal Service Providers, which includes the Resiliency and Justice Center where we serve victims. And like the previous commenter said, just reducing barriers and the power of having something that our navigators can help someone fill out and then we can submit on their behalf so they're not going to the police department and other places for resources that they need is appreciated. So please support the bill. Thank you.
Liz Ortenberger, ORTENBURGER, CEO for SafeNest. We're in support of the bill and wanted to add to the record that we could simply add an email to the blue card that already goes out to domestic violence survivors after police leave that could have an address for a survivor to request that police report. Thank you.
Thank you so much. Is there anyone else here in Carson City wishing to testify in support? Okay, I do not see anyone in Las Vegas, so I will go ahead and open the lines. Broadcasting, please open the lines.
If you would like to testify in support of Assembly Bill 193, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in support at this time.
Thank you so much. Then I will open it up for testimony in opposition of Assembly Bill 193.
Good morning, Chair Miller and members of the Assembly Judiciary. Paloma Guerrero, PALOMAGUERRERO. Clark County Public Defender's Office. This is a soft opposition. We think this is a great bill, but we just have a concern with this happening before a court case is closed. Our concern with the bill is about people's right to a fair trial. In trial, we want witnesses' testimony to be their own. We want them to get on the stand and state their side of the story. We don't want their testimony to be tainted or influenced by outside sources. When police respond to a domestic violence call, they write up a police report, and police are very thorough. They speak to everybody involved, and they write down what each person said, any important evidence that they collected, and the conclusions that they've made. And this bill says that they'll get complete and unaltered copies of all reports. There's an issue with fairness, because if a witness is reading all of these reports before the case has been closed, they're not just reading what they've told police, they're also reading what other people told police, what other evidence was found, and the police officer's conclusions. And in doing that, it can just influence their own testimony before trial. Either way, we want people's constitutional right to a fair trial, and we can't knowingly allow this to happen. That's our biggest concern. We did speak to the sponsor about this, and if we can ensure proper redactions before trial, then we would have no opposition at all. Thank you.
Thank you so much. Not seeing anyone else in Las Vegas broadcasting, will you open the lines, please?
If you would like to testify in opposition to Assembly Bill 193, please press star 9 now to take your place in the queue. There are no callers wishing to testify in opposition at this time.
Thank you. Then with that, I will open it up for neutral testimony. If there's anyone here in Carson City wishing to make neutral testimony.
Thank you, Madam Chair. My name is Maximilian Lowe, Maxmillian Lowe. For the record, I am the Vice Chair of the Nevada Governor's Council on Developmental Disabilities, and today I am speaking on the behalf of myself, as AB 193 is a very important issue to me. As a person with a disability and was a recent victim of a sexual assault by an individual who also receives disability services, and the situation happened in a home run by our service provider in Las Vegas, as we were both DRC clients. Due to the situation of the manner of reporting the incident and how the service provider treated the situation by gaslighting, which led me to report to APS and Metro, as there's a current active investigation going on, as well as to ADSD Quality Assurance and the service provider Chrysalis. I would like to know if there's a way we could add these agencies to this bill, as they are also mandated reporters. Due to this being a recent event and there's an ongoing law enforcement investigation going on, I only would like to know if there's a way that we can have a request to have these agencies added to the records request for investigations, as also there is also going to be an investigation by the licensing board, and that would require this information. Thank you so much.
Thank you so much. And we are deeply sorry for what you've had to experience, but thank you for being courageous with your testimony today. And I am quite certain, if you know, you are sitting next to the bill sponsor, and I am quite certain that he would be willing and able to speak to you later about some of your thoughts and concerns, okay? Thank you so much. Not seeing anyone else here in Las Vegas to testify in neutral broadcasting, will you open the lines?
If you would like to testify in neutral for Assembly Bill 193, please press star 9 now to take your place in the queue.
Good morning, Chair. Good morning, Assembly members. Jason Garrett Gibson with the House of Gibson. GIBSON, calling out of Douglas County, Nevada. A few thoughts here about this domestic violence criminal economy that's engineered by the state, policed by the state, and enriching the state with this gender war. One of the callers mentioned a thorough police kind of investigation reporting when incidents occur. And I can assure you that...
Okay, sir, we're in
Douglas
testimony on the bill, so I need you to speak directly to Assembly Bill 193.
I'm getting to that. The reason why you need this bill is because law enforcement is not adhering to the public information NRS 239 protocol first and foremost. Okay? They are supposed to respond within 5 days, and then within 30 days they're supposed to respond, but that's not what's happening here in Douglas County. They're manipulating those records. They're holding on to those records, falsifying those records, and using those records to profile, target, and harass the male party. Those documents are being used to profile dads and to profile men, and this industry has become something to where 99% of the time, no matter who's making the phone call, the man's going to jail, and the man's being profiled and targeted, and the information in those police reports are, at least in Douglas County, are erroneous. And they're used to gain a 96% conviction rate. And then these women are being they figured it out. They receive compensation for the situation, and they'll be paid $10,000 to $20,000 to relocate to another state, and then they'll do it again. They'll they'll go interstate, and then they'll do it again in the next state, and then they'll bump to the next state, and they're being compensated by the domestic violence purse strings.
Okay, sir,
which was
your
on the
time is
record
up. Thank you.
Yeah, so you don't want to hear. You
caller.
don't want to hear this.
Chair, the public line is open and working. There are no other callers to testify at this time.
All right, thank you so much. Then I will welcome the bill sponsors back up for any brief final words.
Greg Koenig for the record. Thank you for allowing us to present today, and we will meet with the people who have offered some friendly amendments, and we'll see what we can do to work something out. Thank you.
Certainly.
Madam Chair, for the record, William Horn. I'll just briefly address the soft opposition. I'll remind the committee that this is already available for sexual assault victims, right? Number one. So we're just trying to make it for domestic violence victims. Also, in preparation for trials, et cetera, the defendant has access to these in preparation. A defense attorney will use the records to prep their client in case of trial, et cetera, and in negotiations. So it's no different than for victim to have that. Prosecuting attorney will prep their witnesses as well, using statements that they've made in police reports and everything. So I'll leave it at that. Thank you, Madam Chair and committee, for your time.
Thank you so much. And with that, I will go ahead and close the hearing on Assembly Bill 193. Next on the agenda, we have Assembly Bill 216, which revises provisions relating to domestic violence. I will give Assembly Member Hardy a few moments to come forward and get settled. And the same thing, please remember to all introduce yourselves and state and spell your name for the record. And whenever you are all ready and settled, you may proceed.
Thank you, Chair Miller. Good morning to my fellow Judiciary Committee members. For the record, I'm Melissa Hardy, and I'm the Assemblywoman representing District 22 in Clark County. And I'm honored to be here this morning to present Assembly Bill 216, which is an important measure to enhance the safety and protection of victims of domestic violence. Assembly Bill 216 addresses law enforcement response to domestic violence in order to identify and support victims in the most dangerous situations. Domestic violence is a pervasive issue, and Nevada is no exception to the problem. Only 4% of women who are murdered in domestic violence will call a crisis hotline within 12 months of their death. However, 86% will have an intersection with police. For this reason, police officers have a unique and important opportunity to save lives. This bill would require the use of a lethality assessment for all jurisdictions in the state. The purpose of this is clear: upon identifying high-risk individuals, law enforcement can work with the domestic violence providers in the space to provide additional resources, support, and education to victims who are at the most risk. I will now ask William Horn. So William Horn is here with me, and also Liz Ortenberger with Safe Nest. He will go through the bill, and then we can answer any questions. And just to add, we've worked with many stakeholders on various portions of this bill, and there will be some amendments that we're currently working on. But we didn't present with an amendment because we're still working some of that out. But we will address that. Thank you.
Morning, Madam Chair, members of the committee. For the record, my name is William Horn with Western Public Affairs, representing Safe Nest, and I will walk quickly through the bill. And Section 1, Paragraph 1, is basically outlines on the form and what's to be inside the form in making this assessment. For instance, the weapon used against the survivor, there are any threats to kill during that, and do they believe that the perpetrator will try to kill them? Is there strangulation involved, choking in there? Does the aggressor have a gun? Stalking? These are all key signs on reaching that lethality assessment, and you'll find that all in paragraph 1 of section 1. And paragraph 2 outlines what a police officer shall in taking action after doing this. If a survivor responds in the affirmative to these sets of questions that are in paragraph 1, that officer will put this in a report and will inform the survivor of their potential to danger, etc., and services, etc. In paragraph 3, in completing that form, that officer is also going to provide a domestic violence card to the victim. In paragraph 4, if that person is unable to respond for some reason or to the police officer in sufficient manner, that police officer, this outlines on what that police officer should do with the documentation of the lethality form that's created. Paragraph 5 directs the department, that's the Department of Public Safety, creating and maintaining a database of information that's collected, develop training on lethality assessment, and also later in the testimony, Liz Ortenberg will talk through the lethality assessment in the DALE. The Administrative Office of Courts shall also develop training, and that and the department in paragraph 7 may adopt regulations necessary to carry out the provisions of this. And with that wraps up the primary purposes of the bill.
Liz Ortenberger, for the record, CEO of Safe Nest. Clark County is one of the most dangerous places in the country for women being murdered by men. From 1996 to 2020, as the FBI took those records, Nevada averaged third most dangerous place in the country for women being murdered by men, 80% of those homicides taking place in Clark County, and the fair majority of those taking place in Las Vegas proper. We cannot continue to deny that we are failing our women, and then we are also seeing increases in murder-suicides and bystander deaths. This is all preventable using the proper evidence-based technique on the scene by an officer, and then activating a community response, including nonprofit agencies and government agencies, to get a safety net around that survivor. Oftentimes, survivors do not realize if they are being strangled, their children are also being strangled. They don't realize that if they are being strangled, their chances of being murdered are escalating quickly. They don't understand if there's a gun in the home. Their chances of being murdered are 500% higher than that of their peer who's also abused, but there's no firearm in the house. These are all things that can be solved with police officers on the scene doing the proper assessment, educating a survivor, and then surrounding them with services that are provided in those communities. Thank you.
Assembly member, are you ready for questions?
Yes, we can take questions now. Thank you.
Thank you so much. We will start with Assembly Member Roth.
Sorry. Thank you, Chair, and thank you so much for the presentation. My question is just in regards to Section 5, Sub B, regarding the database. One thing that I see sometimes, which I don't know if it's always thought about, is charges for domestic violence can be weaponized against victims by perpetrators. And so I just want to dig in a little bit on the database. Who accesses that? Is that something that could be weaponized against victim survivors? I just want to make sure that we're not kind of wrapping that part into it.
Thank you for the question, Melissa Hardy, for the record. That is one area, number 5 there, in the whole database that we've been having conversations with different stakeholders. So that may be something that we delete, because the intent of my bringing this bill was that all law enforcement jurisdictions perform the lethality assessment. Not that we're creating a database and all these other requirements. It's just that because from what I understand and from in talking with different law enforcement agencies, most of them do these. I know, Las Vegas Metro does them, Henderson, Washoe, they do these, but the intent again is that all jurisdictions perform them, and not necessarily that we're storing these or creating some sort of database. So that's what, like I said, we'll probably delete those sections that relate to that.
Thank you. Our next question is from Assembly Member Gray.
Thank you, Madam Chair. Good morning. Quick question. Will law enforcement officers have to receive training to be able to issue the assessment? I mean, they're not psychologists or anything, and if that training is required, how much time do you think it'll require?
Liz Ortenberger for the record. Thank you for the question. So the DALE, which is the Danger Assessment Law Enforcement, which is the evidence-based metric used by many law enforcement agencies across the country, takes very little training. It's 11 questions. The most important part of that is knowing that if a survivor, there's 3 starred questions, and if a survivor has any of those questions and or is an 8 or above, that's when we're hitting high lethality. And so that's then the process that the police department has to engage in getting other agencies involved. So the training is quite simple. I have a team of 30 staff that administer the DALE on a daily basis. We administer it probably 30 to 50 times a day, depending on volume on our hotline. And the training that we give is about a half an hour.
Thank you. Madam Chair, one quick follow-on.
Proceed.
Okay, so your staff, non-law enforcement officers, they're not actually speaking to the perpetrator. They're garnering these answers from purported victims?
Liz Ortenberger for the record. Yes, both the DALE and the lethality assessment that's currently used are both administered to survivors, not to the perpetrator.
Thank you. Our next question is from Assembly Member Gonzalez.
Good morning. Oh, good morning, and thank you so much for the presentation. I had a question. In your presentation, Ms. Ortenberger, you talked about how you wanted to use best practices, and then in this Section 1, it lines out these specific questions. So I was just wondering why these specific questions and not evidence-based practices that can probably change? Thank you.
Liz Ortenberger for the record. I think that as Assemblywoman Hardy spoke about the amendment, we'll probably clean that up so that we are using the best practices in the field.
Thank you. I also wanted to know, based on this assessment, if the victim survivor maybe doesn't want to answer this at their time, but the officer does have probable cause that they believe they are in this situation, can they still make that recommendation, or does it have to be if they answer these questions? Thank you.
Liz Ortenberger for the record. I can just speak with how we work with LVMPD now. They take the lap assessment. Our advocates are called out to scene if there's a strangulation, a firearm, or the officer believes that our presence will be helpful. Of course, a survivor has the option to not answer the questions. I would believe that our undocumented population would be unlikely to want to engage with any kind of law enforcement at this moment in time. And so what law enforcement, it's going to depend on the county, on what's available to them in the space to get either a softer approach, which would be a nonprofit that can support that, or are they going to send a follow-up team maybe to speak with that survivor the following day or within the following few days.
Thank you. Our next question is from Assemblymember Hanson.
Thank you, Chair, and thank you for bringing this bill. And Ms. Ortenberger, thank you for all the great work that you do. It's certainly appreciated. I'm just curious, as we talk about best practices, and as you address, we'll probably follow up in the amendment, such a horrific subject. And I'm just curious, when things just go wrong, I mean, this is absolutely wrong, but when we have cases, for instance, a young woman, a high-profile case of a lovely young woman that my son actually dated in high school, was killed by her partner, that she'd had continued TPOs, engagement in reports with law enforcement, and also other women had filed reports, and she was unfortunately killed. I'm wondering if the best practices are a reflection of when things go, when there's been all this, there's a footprint here of bad actions, horrific actions. And, I know that we are treading on protecting the accused and also the victim. I'm sorry, it's such an emotional subject. Is there really a good review of what went wrong that will help us know what questions to ask? And so I hope that makes sense. Thank you.
Liz Ortenberger for the record. I'm so sorry that you've been personally affected by this, as probably many of us in this room have been. The state does operate through the AG's office fatality reviews. I think they could be faster and quicker, and it's not to, I sit on that committee, so I'm part of that work. I think we have to meet a turning point in our work, both in the nonprofit space, in the government space, and in the law enforcement space, where we're working together, so that when a lethality does happen, we are what we can review. Sometimes they have to be completely sort of adjudicated before we can do anything through the AG's office. But if we were doing smaller and informal reviews, can we find something that we could have done differently? Because certainly there are gaps in the space that we work in, and that's true for every state. Nevada is not paling in comparison. It just happens to be here that when you put our gun laws and everything together, we tend to be a perfect storm for homicides, which is the number that we generally look at. But to answer your question, yes, there are. I think the state invested $9 million into the opening of One Safe Place in Clark County, which should be a unifying place to bring together all these parties to work through these lethality assessments, even if it's not a true and full lethality assessment, but more quickly, so that we can see what it's like. But we also know most of our folks that are being murdered are living at and below the poverty line. And we have to start to think differently about how we are addressing poverty and violence, and certainly in Clark. I know every county is different, but that's a long answer to your question. But I know that we can do better, and I see many people in this room that are working every day to make this space better.
Thank you. We're going to return to Assemblymember Gray.
Thank you, Madam Chair. I really appreciate what you guys are trying to do, but I have a concern, and I think most of us have seen it happen, where these things can be weaponized against a spouse in a custody case, a divorce case. Is there any recourse for the purported perpetrator, once these things are done, I mean, they're forever going to haunt them and follow them around. I'm really concerned that their due process may be violated in this.
Liz Ortenberger for the record. So currently, at least in Clark, the lethality assessment is used, the LAP, and that's part of their court file. I am not in the court space specifically, but it does not seem to be causing an erroneous legal situation for now. The public defenders might have something different to say, but certainly it's part of the record now. So this would just be tightening it up, making it mandatory, and then really most importantly, cleaning up the space for survivors so that the right supports are put around someone who is escalating towards lethality. And we are all at danger when we are not prosecuting folks that are committing strangulation, right? The mass shooting correlation, the cop killing correlation, and the correlation to not only the survivor being murdered, but many bystanders in the space being murdered by folks committing strangulation. That is the power of these assessments. So they are currently being used in Clark. They are currently part of the legal record. And I haven't seen problems emerging from that, but I'm certainly not an expert in that space.
Thank you so much. Assemblymember Nadeem, do you have a question?
Thank you, Madam Chair, and thank you for the great presentation. So that concerns me, as you said, Liz, that we are third, that Las Vegas is third in domestic violence and assault against women. So do you have some of the reasons why we are third and how we can prevent it?
Liz Ortenberger, for the record, while it's outside the scope of the bill, the research shows that working within the school district with young people, having education and having support systems. In 2019, we passed legislation that would require officers responding to a home where school-age children were present to call Safe Voice. None of that data has ever been made public. We have no idea what the school district is doing to support young people growing up in domestic violence households. And so the cycle continues behind a veil of secrecy. And until, quite frankly, Clark County School District is willing to come to the table and have conversations with providers like myself to say, what can we do? How can we support school counselors? And I'll remind folks, the reason that bill came before the legislature in 2019 is because two young boys watched their mother be murdered by their father on a Friday evening and went to school on Monday. And that school had no idea. And you can imagine that behavior for those young boys was not the behavior the school had normally seen, but what did they do? They disciplined, right? Which is is absolutely not the right angle. So until as a community we start to build a full and complete pipeline of support for our young people that are growing up inside violence, and then having, robust prosecutions, forensic exams, and all the other things that we're talking about, we're hitting in one spot at a time. But that really is the answer. We have to start working with young people and measuring that space and supporting that space with some robust investment.
You invoke CCSD. If, and you're referring to the Handle with Care law. Yes. One of many, many, many laws that I keep waiting for the school district to implement. Many, many laws. And you are correct that often, that's the thing about schools. We're often the only safe place, the only safe adult, the only healthy relationship. And so we are aware oftentimes before anyone else of things going on in the home, even with kids being trafficking, abuse, all types of things. And we know that it was painful that during COVID that the reports to CPS all but vanished because, again, who's the number one reporters? And so, yes, I would love to talk to you more about, I'll talk to anyone about what is or isn't going on. But with that, we will go to our final question from Assemblymember Moore.
Thank you, Chair, and thank you for bringing this bill forward and the work that your organization does. I do have a question about the lethality assessment. When there is a DV call, the police officers show up and they do separate the victim, survivor, and the accused. At what point does the officer determine that they need to do the lethality assessment? Is it only when there was an strangulation or there were physical marks, visible marks that the officers were able to see? At what point does this kick in?
Liz Ortenberger for the record. So let me kind of walk you through the whole thing. So there's about, give or take, 100,000 domestic violence 911 calls in Clark County every year. That's for all police agencies in Clark. Only 30% of those results in the probable cause for an arrest or a warrant for an arrest because the perpetrator's gone. So only 15% of those calls actually have a abusive partner and survivor present on the scene, right? And so from there, what Metro is looking for, oftentimes it's physical signs, and they're better to speak to this to me, because while we have advocates on scene, we're not involved in, what gets a call to be probable cause. But oftentimes it's marks, the general nature of the call, like the situation, right? It is. I will commend our officers every day as we've done ride-alongs. It is a spaghetti bowl of chaos when you get to some of these scenes. I mean, it's hard to tell what's going on sometimes. So they always respond to DV calls as two officers, and they do their great work of separating everybody and doing the interviews. What our recommendation would be, and I don't know where we'll get on the amendment, is that every DV call that's going to result in an arrest, even if the perpetrator has fled, so that's 30% of the calls, should result in a Dale assessment.
Thank you so much. And with that, I will go ahead and open it up for testimony for Assembly Bill 216, first beginning here in Carson City.
Hi, Madam Chair. I'm Maximilian Lowe, MAXMILLIAN LOWE. I'm in support of Assembly Bill 2, this bill, because I also would like to know if you can add disability services with the state and service providers into this bill, because of how I've dealt with a year of verbal and emotional abuse that led up to the situation I was in, and that the service providers said, "Oh, you two, it's just two people need to work it out." And okay, at the beginning, fine. Then it built up, and so because disability services assume that if you receive services and a person with a disability who commits a crime against another person with a disability is not taken care of, and I had a ex-roommate who was extremely narcissistic, emotionally and verbal abuse, and they would not. And even if I wrote behavior reports to the service provider, they would dismiss it. And I would like to have this also required service providers and aging and disability and included in this as well. Thank you so much.
Thank you. And just so that you know the rules of our committee, the rules is that if we testify in support, that means that we don't want any changes to the bill. But I know today's your first day in here, so that's fine. So I will accept your testimony in support, and again, remind you that you are more than welcome to speak to the bill sponsor. I know Assemblymember Hardy, where did she go? Oh, right, I couldn't see her, is more than happy to hear your thoughts and concerns, because we really want to make sure that everyone's taken care of. And thank you so much for your advocacy today. Speaking up for yourselves and other people today. So we appreciate that. With that, we will continue with support testimony.
Thank you, Chair Miller and members of the committee. My name is Elizabeth Abdur-Rahim, ELIZABETH ABDUR-RAHEEM. I am the Executive Director of the Nevada Coalition to End Domestic and Sexual Violence. Lethality assessments are valuable tools that save the lives of domestic violence victims. When used by law enforcement, assessments have been proven to accurately identify high-risk situations 90% of the time. Requiring officers to use lethality assessments and connect victims to advocates when they are responding to a domestic violence incident will simply save lives. Last year across Nevada, 49 individuals died in homicides related to domestic violence. Adoption of AB 216 could help decrease this sobering reality. We urge you to support this bill.
Chair, members of the committee, Jonathan Norman, NORMAN, Nevada Coalition of Legal Service Providers. I think the bill does two things that I think are really important. One, it creates uniformity in the form that's used across the state, and two, it provides training for officers. And then I echo the comments of my colleague here. And certainly, we support it as it's written. If there's an amendment that says best practices, we're going to support that as well. Thank you so much.
Chair Miller, members of the committee, Leslie Pittman, representing Domestic Violence Resource Center again, and in full support of this legislation. We conduct lethality assessments of all of the clients that show up at our doors seeking resources, and we believe to have law enforcement doing the same and having a standardized practice across the state would be helpful in saving lives. Thank you.
Thank you so much. Is there anyone else here in Carson City? I'm going to ask that you say your name and spell it for the record, and then please try to keep your comments to 2 minutes. Turn your microphone on.
Jessica Glover, Jessica Glover. So I am for the new bill. I would actually like that narcissistic personality disorder be included in domestic violence situations. What people don't understand about domestic violence is the scars and the wounds are not always visible. Narcissistic personality disorder is an emotional and mental abuse. For several years, I was emotionally and mentally abused. I went to law enforcement, I went to advocates and different organizations in the community within Northern Nevada, and I was discarded as the narcissist wanted me to. I ran for Reno City Council in 2024. I am the voice for the unheard and the souls for the unseen.
Thank you so much for your bravery today and your testimony and your advocacy. Is there anyone else here in Carson City? Not seeing anyone or anyone there in Las Vegas. Broadcasting, please open the lines.
If you would like to testify in support to Assembly Bill 216, please press star 9 now to take your place in the queue. There are no callers choosing to testify in support at this time.
Thank you. Then I will open it up for opposition testimony for Assembly Bill 216. And I would just like to say, because I know we have some people here today in Carson City that we don't see every day, and this may be your first time in Carson City, I want you to understand that opposition testimony is not against any person or group, and it is most definitely not insensitive to situations. What the opposition testimony that we're going to hear is that they just have concerns about the bill itself as it's written, and so I know all these individuals, they care deeply about these issues, but their concerns are about the bill, how it's written, okay? So with that, please proceed.
Good morning, Chair, members of the committee. My name is John McCormick, John, last name McCormick, McCormick. I'm the Assistant Court Administrator at the Nevada Supreme Court Administrative Office of the Courts, and I am here in opposition specifically to Section 1, subsection 6, which requires the Administrative Office of the Courts to make the training developed by the Department of Public Safety available to any person who, during the scope of her employment, has regular and routine contact with the results of an assessment. We feel that subjecting the AOC to the administrative regulatory authority of DPS and making AOC deliver this training may be constitutionally problematic, and that's our only concern with the bill.
Good morning, Angela Knott from the Washoe County Public Defender's Office, ANGELAKNOTT. So Washoe County is already using lethality assessments, but we're using them with our pretrial services department. This is a pretrial services tool that is being used to help support domestic violence victims, but it's also being used against defendants at their bail hearings. We believe this should remain as a pretrial services tool and should remain with them because pretrial services can be a little bit more neutral than a responding police officer on the scene. And when pretrial services uses it, the standard can become a little bit more, I guess, standardized, right? So they're a smaller unit. They can all be using the same assessment and know how to use the assessment because they're using it all the time. The concern with police officers is that there are many different departments. We have Reno, you've got Sparks, you've got Washoe County Sheriffs, and then you have all the rules. So they're all going to get the training, but I think a lot of it would depend on how much training they have, how many years of experience they have when they come to respond to a case, and you have more of a chance for bias when you're coming to assess to conduct the assessment and differing ways you execute that assessment. So keeping it with pretrial services helps to standardize how it is used. Another issue that was raised was, what if an officer fails to conduct a lethality assessment and harm follows from that failure to conduct the lethality assessment? What happens to that police officer? Will there be civil complaints? Will there be civil criminal charges? So how do we protect the police officers in these? And I really like the word spaghetti bowl of chaos, because sometimes it is chaos. And then lastly, Assemblyman Gray, his due process concerns with these lethality assessments bring up are what's called uncharged other bad acts. So we have to address those at trial. Thank you.
Thank you so much.
Paloma Guerrero, PALOMA, Clark County Public Defender's Office. We had two concerns with the bill. The first one was Section 1, subsection 5B, which the bill sponsor addressed. Those are database concerns, and we thank the bill sponsor for being open to modifying that. The second part is with Section 4, subsection 8, and that's putting into statute the consideration of the results of lethality assessment in bail. Subsection 8 already states that when a judge is considering bail, the nature and seriousness of the danger to the alleged victim is to be addressed. So which in effect, this already encompasses those results, and in practice, judges are already doing this. In Clark County, the judges are seeing these results and doing it. There's just an issue with codifying this into law because the assessments are so new and they could change, and the language in the statute is already broad enough that it can encompass whatever future iterations that these assessments can take. And again, thank you for the bill for bringing this important bill. I'm sorry, bill sponsored for bringing this important bill. Thank you.
Good morning, Chair Miller, the Assembly Judiciary Committee, and your esteemed guests. Based on the rules of the committee, my name is Chris Reese. It's R-I-E-S. I represent Las Vegas Metropolitan Police Department. Simply based on the rules of the committee, we are in opposition. We've had discussions with Assemblymember Hardy regarding our concerns, and we are confident that we can get to a position of support. But I do want to make one thing clear, that the lethality assessment is a very important tool to assist us in coordinating response to provide services to victim survivors. I also think it's a very important tool for the courts to establish the bail, as well as informing victims of the harm and the risk that they are in. So again, we are in opposition simply because of the rules of the committee, but we do think we can get to a position of support. Thank you.
Good morning, Chair Miller, members of the committee. I am Jason Walker, Jasonwalker, representing the Washoe County Sheriff's Office. Thank you, Assembly Member Hardy, for bringing the bill forward. I, like my colleague, am looking forward to working with Assembly Member Hardy regarding the amendment.
Thank you, Chair Miller, members of the Assembly Judiciary Committee. My name is John Jones, here on behalf of the Nevada District Attorneys Association. We too are, pursuant to the rules of the committee, opposed, as currently written, to AB 216. I do want to thank Assemblymember Hardy for talking to us about the bill, and I would like to adopt everything that they said during their bill presentation. I completely agree with it all. Our big concern now is putting the specific language of the assessment in statute. I do think it is better developed as a policy so we can constantly update it considering what the best practices of the day. And with respect to officers and victims, if a victim refuses to participate in the lethality assessment, what we see now in Clark is the officer just writes refused. And as you can imagine, with domestic violence cases, some victims refuse to participate in the investigation. That is normal. Unfortunately, it's normal, but it's normal. And so we don't compel victims to answer these questions if they are not ready at that time to answer them. So I don't see this as something that's compulsory or that officers are going to make up. I'm happy to answer any questions the committee may have.
Not seeing anyone else here in Carson City, and there's no one in Las Vegas. Broadcasting, will you open the lines, please?
If you would like to testify in opposition to Assembly Bill 216, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in opposition at this time.
Thank you. Then I will open it up for neutral testimony. If there's anyone wishing to testify in neutral here in Carson City. Broadcasting, will you open the lines?
If you would like to testify in neutral for Assembly Bill 216, please press star 9 now to take your place in the queue.
Good morning, Chair. Jason Garrett Gibson on behalf of the Foundation for the Law of Time. My comments would be best reserved for a public comment. We speak in whole systems. I know this is a neutral opportunity to testify. What do you think would be best if we wanted to offer solutions to this body?
Then I would, if you want to offer solutions, email the bill sponsor, because it's often easier.
Is there going to be a public comment?
There's always public comment at the end of the
We
meeting.
do that as well.
But public comment is not
Okay,
to
in some
speak on the
committees, they
bill.
have public comment.
I've explained the
Gotcha.
rules of the committee.
I'll
Yes,
pass
thank
the
you.
Chair, there are no other callers to testify in neutral at this time.
Thank you so much. I will welcome the bill sponsor back up for any final words.
Thank you, Chair Melissa Hardy, for the record. And like I said in the beginning, I appreciate everyone that has come to me and talked about some of their concerns. And like I said, there are specifically Section 1.6 we're going to delete, and there's some other sections that we're also going to delete as well. As I said, the intention wasn't for the Department of Public Safety to take this on. So we'll fine tune that. And then we've also had conversations about a form and the assessment itself. So I'm sure that working with everyone, we can get to a place where everyone would agree. But I think from all the comments, we collectively see the importance of doing these assessments and the value that they add. It's another tool to help these victims and help law enforcement and all those that are involved in these cases, protecting them and having the best outcomes for them. So I appreciate you all hearing the bill today and for your comments. Thank you.
Thank you so much, Assemblymember, and we look forward to your amendments. Assemblymember Hardy, you may stay there because as I close the hearing for Assembly Bill 216, I will open the hearing for our final bill today, which is Assembly Bill 272, also sponsored by Assemblymember Hardy. This revises provisions relating to forensic medical examinations. And so whenever you and your co-presenters are ready, please proceed.
Thank you, Chair Miller. It's good to be here. I'm Melissa Hardy, for the record, representing Assembly District 22. So AB 272 is another bill that is in the domestic violence space. This bill is designed to allow direct billing from licensed medical facilities for forensic exams given by their licensed forensic nurse. Currently, legislation requires the billing for these exams to go through the county, causing a bottleneck for exams and lack of access for survivors. I will now ask William Horn to walk you through the bill. And again, Liz Ortenberger with Safe Nest are here to help field questions. Thank you.
Morning, Madam Chair, members of the committee. For the record, my name is William Horn. This is the most time I spent in this committee since 2011. By the way, so bear with me. So in section 1, paragraph 1, it basically lays out that that costs for these forensic medical exams may not be charged directly to the subject of the exam, and that in paragraph 2, that healthcare facility may apply to the Department of Health and Human Services for reimbursement. The purpose of this bill is to have more direct billing, not having to go through the county and then county billing the state. In paragraph 5, that department shall adopt regulations on how to establish the procedures on seeking reimbursement. In paragraph 7, the forensic medical exam is defined as the scope of not only victims of sexual assault, but also victims of domestic violence and strangulation and human trafficking outlined there. In section 2, you'll see down in paragraph subparagraph F has been deleted because that's the deletion toward the county. As I mentioned, we're trying to streamline this on charging reimbursements. And paragraph 2, you'll see that forensic medical examination definition is defined by statute. Again, has been redefined over in paragraph 7 of section 1. The other deletions that you see throughout the section are also to bring it in line with the billing procedures of billing directly to the state and Department of Health and Human Services as opposed to the county. And that is pretty much it for the bill and those outlined deletions.
Liz Ortenberger, for the record, CEO of Safe Nest. We have been working on the forensic medical situation in Clark County for quite some time. Currently, we have one forensic nurse in Clark County for 2.4 million people, 3 million on a busy weekend. Our original thought was that the problem was we didn't have enough forensic nurses. Actually, there are 26 forensic nurses in Clark County, but because of the way the billing system has been set up, which is that the hospital has to bill the county and the county has to bill the state, and on top of that, there was a limit of only 10 exams or $10,000 in reimbursement annually. It did not make sense for Clark County at all and started to explain the bottleneck. So we worked in the interim on figuring out what this billing system looks like and why can't we just bill directly to the state, which would allow more licensed medical facilities to have forensic nurses on staff and get then reimbursed for those exams. To be clear, there are only two kinds of exams that can be reimbursed by the state out of victims of crime is a SANE exam, which is a sexual assault nurse examiner exam. Out of the fund that we created last legislative session are strangulation exams. These are just the exams, not the incurring medical treatments that may be needed by the survivor. It is simply the exam portion of the process. Thank you.
And we are ready for questions.
Thank you so much. We don't have any questions. It does happen on occasion. It's even happened to me. Yeah, it happens on occasion. So I'm going to say run quickly so I can open up testimony. I will start with support testimony for Assembly Bill 272, starting here in Carson City.
Good morning, Chair Miller, members of the committee. My name is Jeff Rogan, Jeffrogan, and on behalf of Clark County, for the reasons that were stated on the record during the bill presentation, we are in support of this bill and thank the sponsor for bringing it forward.
Good morning, Chair Miller. My name is Chris Reese, R-I-E-S, representing Las Vegas Metropolitan Police Department. To be brief, ditto.
Good morning, Chair Miller, members of the committee. Jason Walker, Jasonwalker, representing the Washington County Sheriff's Office. I echo the comments that were made previously, testifying in support.
Thank you so much. Is there anyone else here in Carson City? Not seeing anyone in Las Vegas. Broadcasting, will you open the lines?
If you would like to testify in support of Assembly Bill 272, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in support at this time.
Thank you. Then I will open it up for testimony in opposition of AB 272. Not seeing anyone here in Carson City or Las Vegas. Broadcasting, will you open the lines?
If you would like to testify in opposition to Assembly Bill 272, please press star 9 now to take your place in the queue. There are no callers choosing to testify in opposition at this time.
Thank you. Then I will open it up for neutral testimony, beginning here in Carson City. Not seeing anyone approach. Broadcasting, will you open the lines, please?
If you would like to testify in neutral for Assembly Bill 272, please press star 9 now to take your place in the queue. There are no callers choosing to testify in neutral at this time.
Thank you. Then I will welcome the bill sponsor up for any final remarks.
I just want to thank the committee for hearing these bills today. It's been a pleasure to be here in front of you, and we will update you on the progress. And thank you again.
Thank you so much. With that, I will go ahead and close the hearing on Assembly Bill 272. Our last order of business today is public comment. Again, asking anyone speaking to please say their name and spell it and keep their comments to 2 minutes. We will start here, and also a reminder that public comment is not to comment on any of the bill hearings that have already been closed, but for issues that are under the purview of this committee. So we will begin here in Carson City.
Hi, I'm Maximilian Lowe, Maxmillian. I would like to hope to see that disability services have training in some of the things to deal with a lot of laws that help people with victims of crime, because it's not taken seriously, rather, especially in Las Vegas and Clark County alone, and this is why I moved up to Carson City, and that we should all, I believe that we should also train our service coordinators with the regional centers, as well as all the service providers that serve the disability population, because an understanding that people with disabilities who commit a crime against another person with a disability it's not taken seriously, and I'm not the only person. And for example, I have a friend who lives in North Las Vegas that the same service provider is doing the same exact thing to what they did to me, and I had to make an APS report. So we need to, I know that CPS, APS are very well, and law enforcement are well into this, but the service providers and service coordinators with all the regional centers should be also educated, because if they don't, they just, because they don't understand what's going on and it's not taken seriously. Thank you so much.
Thank you so much. And we've certainly appreciated having you here today. Thank you. Not seeing anyone else here in Carson City or Las Vegas. Broadcasting, will you open the lines, please?
If you would like to provide public comment, please press star 9 now to take your place in the queue.
Jason Gibson, calling on behalf of the Foundation for the Law of Time, American States Assembly, new Nevada State Assembly, over 40 years in the support of Doctors Jose and Lloydine Arguelles, and as of recent under the tutelage of Justice Anavon Wrights. We speak in whole systems, where the part contains the whole. It should be of no surprise that Nevada leads the way in terms of domestic violence, and all of the statistics and things that we've heard this morning are absolutely tragic. It's a wasteland that you've created, a commercial wasteland. It's rooted in an identity crisis. We can start by returning to our constitutional charter, which is a corporate charter. Unfortunately, it's been co-opted. That contract should be taught in our schools, and it should be remembered and recited frequently. Every year, we're supposed to have a week-long commemoration to the state and federal constitution. But also the fact of the matter is that many of the heads in this room have not heard of the World 13 Moon Calendar Change Peace Initiative and the Rorich Peace Pact of 1935. This is absolutely tragic, especially when the discovery of the law of time makes conscious what's unconscious, which was brought forward in 1989 by Doctors Jose and Lloydine Arguelles. We are at the following websites. Thank you. www.lawoftime.org/history. 13 months, 28 days.info. It's the number 1328. It's on the back of every dollar bill. In God we trust. Supposed to be living by the organic order and the natural law. Got a great deal of violence happening because we've deviated from the harmony of the organic order. And we are also to be found
thank you
at
so much.
Harmonic Factor.
Sir, your time is up. Thank you so much. Broadcasting, next caller.
The public line is open and working. There are no other callers to testify at this time.
Thank you. Well, with that, I will go ahead and close public comment. And we have concluded our business of the day. And I will go ahead and adjourn this meeting and see you all back at 8 a.m. tomorrow morning. You're welcome.